Thank you, Acting Deputy Speaker. It gives me great pleasure to rise to speak in favour of the Migration Amendment Strengthening Employer Compliance Bill 2023. And I'd like to acknowledge the fantastic contribution to this debate from my good friend, the member for Holt just now. Our parliament is so much richer for having you here. This is an important additional step that the Albanese Labor government is taking toward ensuring that all workers that work in Australia can be free from being exploited by unscrupulous employers. And they do exist out there, Speaker. Protecting the vulnerable and protecting workers are deeply embedded in the DNA of members of the Australian Labor Party. This is true of those within the Parliamentary Labor Party and of the broader membership. The most eye-opening statistic amongst many worthy contenders are that up to 1 in 6 migrants are paid less than the minimum wage. This does not exist in isolation. Migrant workers being paid less than the minimum wage affects all workers, for when employers think they have found a way to pay any kind of worker less than what is set at the base level. When left unchecked, it brings down the minimum standards for all of us, not just wages but conditions too, unless mechanisms exist in law to deter and punish this kind of behaviour. In fact, recent migrants are 40% more likely to be underpaid than long-term residents with the same skills, with same level of experience, doing the same job. Temporary visa holders comprise 4% of our total workforce in Australia, but within the 21-22 year, migrant workers made up 26% of all litigation initiated for breaching the Fair Work Act. Speaker, on the eve of the Australian Labor Party's national conference in a few short weeks, I look back to our national platform that was endorsed back in 2021, where the section that is quite germane to this bill reads as follows. Temporary overseas workers are vulnerable to exploitation, and this exploitation affects those workers and all Australian workers by undermining their wages and conditions. Labor will ensure that migrant workers, including temporary visa workers, have access to adequate information on their workplace rights and how to join their union. Another pertinent section reads, too often, temporary migrants end up exploited or underpaid, with some employers abusing the system for cheap and disposable labour. Labor will always ensure that measures are implemented to protect all migrants from exploitation, including requiring temporary migrants to be paid in accordance with Australian awards or enterprise agreements and to have their wages paid into an Australian bank account, ensuring temporary migrants are protected by Australian workplace law and are not exploited through sham contracting or unethical labour hire practices to give them, and offering them whistleblower status if they are providing evidence of exploitation. This will be my first national conference as a member of this place and a member of the Federal Parliamentary Labor Party. There is a feeling of pride in making a contribution on legislation like this, or any of the multitude of measures this government has introduced in this 47th Parliament that moves the dial closer to parity between employees and employers. In this instance, the pride I feel boils down to being part of supporting legislation in this place that accomplishes these parts of our platform that I had mentioned earlier. And why might that be? Because, as I had said earlier, it is in Labor's DNA to stand up for workers. Further to this point, if one were to use private members' business as a litmus test for this theory and to seek the sheer extent of contrast from those opposite, I saw 2 motions last week. One moved by the member for Holt on this exact issue, combating the exploitation of migrant workers in Australia. In most part, it was an extremely gracious debate where we broke bread and agreed that a problem existed. Many anecdotes of exploitative practices that were aired were utterly reprehensible and deserving of sanction, and we look forward to real action to combat this. Then we had the member for Sturt laying blame at the feet of the union movement, and he couldn't imagine a world where any small business owner might be tempted to engage a temporary migrant employee contrary to our industrial laws. The member for Sturt even went so far as to say the union movement's ultimate goal is to constrict migration. How does that stack up when key members of the opposition's brain trust, namely the Leader of the Opposition himself and the member for Hinkler, have criticised the government for letting migration levels rise to a slightly lower level than what they, when in government, modelled would occur prior to closing the borders at the advent of the COVID-19 pandemic. Their criticism can only mean they are advocating for pandemic-era border closures. But of course, it is Labor and unions that are against migrant workers. Frankly, from now on, I am hoping those opposite do an appropriate amount of warm-up stretches before engaging in debate on immigration or industrial relations, because the flexibility they must possess to somehow occupy both sides of this argument and blame Labor, it is quite impressive. If I were a high school debating adjudicator, I'd be awarding some pretty high marks for that effort, but it's just a game to some of them. On our side of the chamber, it is anything but. As those opposite point out until blue in the face, we are full of ex-union officials, myself being one of them. We have seen what exploitative workplace practices can look like in the real world, the effects it has for workers, not just their hip pocket either, but their self-esteem, their mental health. It doesn't matter where you are born or what type of conditions someone has to work in Australia. If you are working here, you deserve the full complement of workplace rights as everyone else. Allowing the derogation of workers' rights, conditions, entitlements, minimum standards of our domestic workforce will hurt our migrant workforce, and the opposite is just as true too. But it is our migrant workforce that face additional vulnerability and susceptibility to fall prey to unscrupulous practices. This bill particularly aims to tackle the exploitation of migrant workers, something that has been exposed for its prevalence through a number of reports. A report of particular significance that has led to this bill is the one handed down by the Migrant Workers Task Force. Additionally, a slightly more contemporary report that I will encourage members to read when they can is a report published by the Grattan Institute earlier this year called Short-Changed: How to Stop the Exploitation of Migrant Workers in Australia. The Migrant Workers Task Force was commissioned to report to government, largely due to the shocking revelations that were reported on in the media concerning 7-Eleven franchises, a company where migrant workers, namely international students, dominated its main workforce. Further investigations confirmed many of the reports by the media where workers were systematically underpaid, with franchisees going so far as to falsify records to hide these underpayments. It was quite evident that, namely due to the prevalence of this transpiring amongst 7-Eleven franchises, the exploitation of migrant workers was baked into their business model in some of the most egregious ways. The Migrant Workers Task Force report was handed down to the government in early 2019, and to their credit, a response to the report was given by the government at the time mere weeks afterwards. This is something the Morrison government was known to have formed for. However, the timeline after that response was handed down is more on brand for the former government. The recommendations of the Migrant Workers Task Force, in addition to the bill introduced by the previous government lapsing in the 46th Parliament, culminated in this government introducing its own bill, this bill. Without delving into every tiny detail contained within the bill, I will attempt to paint the measures contained within by way of broad strokes. Part 1 of this bill introduces new employer sanctions against the Migration Act. This part implements Recommendation 19 of the Migrant Workers Task Force report, which proposes that the government develops legislation so that a person who knowingly unduly influences, pressures or coerces a temporary migrant worker to breach a condition of their visa is guilty of an offence. These circumstances will include circumstances where a person knowingly or recklessly coerces or exerts undue influence on a lawful non-citizen to work in breach of their work-related visa conditions, an unlawful non-citizen to work to avoid an adverse effect on their continued presence in Australia, and a lawful non-citizen to work to avoid an adverse effect on their immigration status or to avoid being unable to acquire the required information or documents regarding their work for visa purposes. The maximum penalty associated with each of the offences listed above shall be 2 years imprisonment or 360 penalty units. The civil penalty associated with these offences are set to 240 penalty units, which, however, are distinct from the offences given the state of mind of a person is not required to be proven in order to form all of the required elements of the civil offences. Meaning, if an employer coerces an international student to work more than what the hours in their visa permits, the employer will be committing one of the offences above to a standard dependent on the circumstances involved. These provisions satisfy a number of aims: to deter others, to punish those in breach, and to protect migrant workers from coercive practices by employers that would find them in breach of their visa conditions with respect to the manner that they can work and for the amount of time they can work during a given period of time. These exploitative practices of migrant workers need to be dealt with strongly, and the amendments to the Migration Act in Part 1 have been a very long time coming, much like the others proposed by the Migrant Workers Task Force. Part 2 of the bill concerns the conditions to which an employer may be prohibited from employing temporary migrant workers. Through this part, the minister or their delegate can prohibit the hiring of additional workers on a temporary visa where an employer has underpaid or otherwise breached their obligation as employers. The circumstances to which they can occur are also set out in this part, through how a person can be subject to being subject to a migrant worker sanction. Once a person has satisfied the criteria to be subject to a migrant worker sanction, the minister or delegate may declare that person to be a prohibited employer for a 5-year period, each time a person is subject to a migrant worker sanction. The part further outlines what happens once someone has been declared a prohibited employer, namely the penalty for allowing a non-citizen to begin work, whether for reward or otherwise, that being 2 years imprisonment or 360 penalty units or 240 penalty units as a civil penalty. The part also provides an affirmative duty to name and shame prohibited employers on the department's webpage. Part 2 also provides for the procedures for the 12-month period after a person's term as a prohibited employer concludes, with a number of interim conditions imposed, such as the requirement to report on any new temporary migrants that are employed during this time. Part 3 of the bill increased the pecuniary penalties that currently exist for work-related civil penalty breaches in the Migration Act and for breaches under current existing employee sponsorship obligations in the Migration Act and the Migration Regulations 1994. Part 4 of the bill establishes a framework whereby the minister or their delegate can enter into enforceable undertakings with an employer, labour hire company or other party that has breached a work-related offence or other such provisions under the Migration Act, which would include the new civil penalties and offences provisions within Part 1 of the bill. Part 5 of the bill establishes a framework enabling an authorised officer to issue a compliance notice as an alternative to initiating court proceedings for contraventions of work-related provisions of the Migration Act. And Part 6 of the bill comprises a number of ancillary amendments. I commend this bill to the House and would urge the support by all members to put to rest amendments to the Migration Act that have been sorely warranted and called for by several experts, a number of parliamentary committees, and by virtue of the lapse bill in the previous parliament, the Migration Amendment Protecting Migrant Workers Bill 2021. You could even extend that through to the opposition as well, given they were in government when introducing similar legislation into the 46th parliament. This is one big step forward to eliminating exploitative employment practices against our migrant workforce, a workforce that Australian employers cannot take for granted, and especially one that employers can't abuse their fundamental rights and protections under Australian industrial law with wanton abandon without risking the full weight of that law by trying to do so. It has been flagged that this is by far not the complete cure, but these are measures that have been asked for now for a significant amount of time that will go a long way to addressing the problem, to minimising its prevalence in pockets of Australia, whilst also maximising the likelihood of workers feeling comfortable enough to report breaches by their employers, prospective employers or former employers, to the relevant authorities. Thank the House.